Well, greetings, test takers. This is Dean Tenney. I'm coming to you from my studio here in fabulous Las Vegas. We've been doing a series called Series 7 in 60 Minutes, SIE in 60 Minutes, 66 in 60 Minutes. And people have found them helpful. They originate from people who are watching videos the day before their exam or the morning of their exam on audio, kind of driving to the site just to kind of get their rhythm, get in the flow. Because, particularly NAS exams, not a natural circadian rhythm. And so I thought, well, gee, let's make a video where mainly audio. I'm not going to have the slides up or anything like that, just to kind of get you in the mood, I guess would be the right way. A lot of test takers have found it successful for other exams. So here's the 63 version of that. And like I say, you might want to use it as intellectual inventory. If you are not taking the exam tomorrow or this afternoon, then please save this, put it in your save and for the right time. It's not designed to be a learning tool. I will link to two very important lectures if you're taking a NASA exam, the Mighty 90, the Uniform Securities Act in 90 minutes, which you can watch anytime. I think is very helpful. It's one of our most popular lectures on the channel. And Who's Your Daddy, about who does the investment advisory firm belong to, either the SEC or the state. So I'll link probably just the Mighty 90. You can find the other one on your own. All right, so let's get started in terms of the Series 63 in 60 minutes. So let's first talk about registration of persons. Keyword registration. Now, persons, you're taking a legal exam, and a person on this exam is not necessarily what you would think of as a person. What I mean by that is a person is somebody who can be held legally accountable for their behavior. Now, there are unnatural persons. Those are not living human beings, living, breathing human beings walking planet Earth. And there are natural persons. Those are living, breathing human beings walking planet Earth like yourself. Now, what we care about that is that the broker-dealer in the cast of characters, the investment advisor in the cast of characters are unnatural persons, but they can still be held accountable for their behavior, whether they're organized as a corporation or an LLC or a partnership, whatever the case may be. And you, as an agent of the broker-dealer, a natural person, can be held accountable for your behavior. And you, as a natural person who's an investment advisor representative for it, can be held accountable. Now, 63 assumes you're going to be an agent of a broker-dealer, a natural person who's an agent of a broker-dealer. So let's talk about registrations and the cast of characters. So remember, the other cast members that would also be unnatural persons would be institutional investors, for example. And what you really got to get a handle on is who's not considered to be a person. And so it's very important to know persons, remember, that they're not persons, meaning they can't be held accountable for. And that would be minors. Minors can't be held legally accountable because they're not persons under the Uniform Securities Act and in the law in general. A dead person can't be held legally accountable because they're not a person under the Uniform Securities Act. And somebody who's been declared mentally incompetent. Now, again, we're talking about registrations of persons, and we said, the cast of characters also would include issuers. Issuers would be unnatural persons. They too can be held accountable for their behavior. And so an issuer means any person who issues or proposes to issue the security. So if you propose issuing a security, then you become under the Uniform Securities Act an issuer and subject to the jurisdiction of the state administrator. So offer or offer to sell. So are we making an offer in the state? Or, this kind of, again, is important, but I'm coming to you from Nevada. I would highly recommend that you do the same. Put yourself in whatever the question is. So I'm making an offer that originates in Nevada. That means, Dean, I'm coming to you from Las Vegas, Nevada. I directly offer to you in California. So the offer originated in California. It was originated in Nevada, was directed to California. So there are now two states that have jurisdiction, California and Nevada. And so you're in California. You said, Dean, I want to think about it. I said, I'll call you back tomorrow. I call you back tomorrow. I said, hey, have you thought about it? He goes, yeah, Dean, I'm up here in Oregon, and I've decided to go forward with the investment. So now there's 3 states that have jurisdiction over that offer. The state where it originated, Nevada, the state where it was directed, California, and the state where it was accepted, Oregon. I say, hey, great. How are you going to send the money to me? You say, Dean, I have a family office in North Dakota. I have my banking relation up there, and my bank in North Dakota will send you a cashier's check. Please note, North Dakota has no jurisdiction on it. It's not where the bank or the check is drawn that has jurisdiction. I said, great, I'll be looking for it. Listen, the physical certificates, the evidence of your ownership, the certificates, the transfer agent resides in Colorado. And so I'll be looking for the certificates to be sent to you from Colorado. And again, Colorado has no jurisdiction based on where the certificates were mailed from, where the transfer agent is, the fancy word for that is domicile, right? Where the bank is domiciled, North Dakota, or the transfer agent. This test comes from the 1950s. So I know that some of you probably have never seen a stock certificate, probably will never see one in your career. But remember this thing, the template of the Uniform Securities Act comes from the 1950s, right? Remember, there's more than 50 state administrators because North American Security Administrator Association includes Canada, which is a part of North America, right? So, provinces would be the same as states on your exam, and the cities in those provinces, like British Columbia is a province, no different than Nevada as it relates to the Uniform Securities Act, and Vancouver is no different than Las Vegas. Okay, so an offer accepted becomes a sale. It doesn't really matter because they still have jurisdiction. And then broker-dealers, remember, broker-dealers have to register, we know, with at least one state because I'm going to have a home office. So if I'm a broker-dealer, I'm going to register with the SEC, FINRA, and most importantly, any state in which I have an office. So I have a home office, and then any other state in which I have an office, regardless of the type of clients I have. Now, if I don't have an office in the state, and I don't have retail customers in the state, well, then I'm not going to have to register in that state, right? So my broker-dealer had institutional customers in New York. I don't have to register in New York if I don't have an office there. My broker-dealer had an office in Virginia. I only had institutional investors, doesn't matter. I have an office in the state. I'm going to have to register in the state. By the way, be careful too. There's no de minimis for a broker-dealer. Broker-dealer has one retail customer in a state, and they're going to have to register the broker-dealer in the state. There's exclusions for registering in a state if I have no office in the state and I have a snowbird, right? So, I'm registered in Michigan. I have a Michigander as a customer, and they are snowbirds spending the winter in Las Vegas. I don't have to register in Nevada. Now, remember, if they do decide to move to Nevada, well, then I'm going to have to register that. But if they're existing customer, I say to the state of Nevada, they're a Michigander, and the state administrator of Michigan is protecting them. I think of the state administrator as protecting the investors in their state. Okay, so let's talk about you as a person. You're an agent of the broker-dealer, and you're certainly going to have to register, right? Because you're helping the broker-dealer transact business in the state, right? So you're going to have to register. You do so, as you know, through a Form U4. Now, there are exceptions if what you're doing for the broker-dealer is solely clerical in nature. So there are exceptions, for whether somebody has to be registered. Again, solely clerical in nature would be the pivot word that, you're answering the phones, you're pushing paper around, you're not making public contact regarding investments. Let's see. I've made some notes about what I want to cover in these 60-minute versions. So let's see, what else do I want to cover with you? Sometimes people get hung up on the exempt transaction. There's no situation in which the associated person, the agent of the broker-dealer, is not going to be registered. If they're selling securities, regardless of the type of security they're selling. So just be careful on that. Splitting commissions. You can split commissions on the exam? The answer is yes, with somebody who's properly registered. Do you have to disclose the split on those commissions? You do not. So you don't have to tell customers about how you're splitting commissions if you're working as a team. Investment advisor. So an investment advisor, remember, we have an ABC test. Does the unnatural person, whether they're organized as a corporation or partnership or LLC, do they give investment advice? Do they tell people in the business of giving their investment advice? and do they want compensation? That's the ABC, advice, business, compensation. And then remember, the SEC said, some people asked, well, I'm not sure if I am an investment advisor or not. And, the SEC sent out a release 1092 and said that, if you're, a financial planner or you're a sports agent or you're a pension consultant and you are giving investment advice and you're charging for it, you are an investment advisor. Now, I wish there were more memory aids on your exam. There's not a lot of memory aids found in your, NASA exams, including the 63. But one, remember, we have is late, L-A-T-E, late. If you're a lawyer and the legal advice you're giving is incidental, again, key word, incidental. You're an accountant and the investment advice you're giving is incidental. You're a teacher and the investment advice you're giving is incidental. If you are an engineer and the investment advice is incidental, then you don't have to register as an investment advisor. Now, once you cross the threshold and it's not incidental, well, then it'll trigger registration. And I can tell you how many lawyers end up having to take these NASA exams because they've crossed the line of where incidental is. They're actually giving investment advice and they're charging. The assumption here is that as a customer or retail investor, I kind of do think an attorney might know a little more than myself about investments, particularly if, he just won me like $100 million settlement. Maybe he's a personal injury attorney. He says, Dean, 66 million for you and 33 million for me. My contingency fee is a third of the money I collect. And I go, well, hey, that's wonderful. But I don't begrudging you that. 66 million of 100 sounds fair to me. Hey, what do you think I should do? And, maybe he says, well, why don't you talk to my guy I know who works at a broker dealer about a mutual fund? He just gave investment advice. It was incidental. Okay, so if we are an investment advisor, remember there's what's called the National Securities Market Improvement Act. And what the National Securities Market Improvement Act did was create two buckets. The state administrators weren't very fond of this because it created what are called federally covered investment advisors. And, if I'm federally covered, then I don't have to register with any state. You're never, as an investment advisor, going to register firm. We're talking about the firm, not individuals. You're never going to have to register with both the SEC and the states. It's one or the other. And the other thing it did was create federally covered securities that don't need to be registered under the Uniform Securities Act. Right now, we're talking about registration of persons. And so we're talking about registration of an investment advisory firm and whether they're going to register with the state or the feds. Now, it's based on assets under management. So if I'm an investment advisor and I have 100 million or more in assets under management, I can choose to belong to the SEC. If I have assets under management of 110 million or more, then I'm federal for sure. If not, then I belong to the state. Now, there's also a floor. So when, I have 100, and then, I can go down to 90 before I get kicked back to the state administrator. Now, if I'm a federally covered investment advisor, as I just said, I'm not registering with any state. But, the investment advisor, representative, may or may not have to register. But, if I'm an investment advisor in state A, the de minimis, by the way, only applies to state covered. If I'm federally covered investment advisor, I don't have to worry about how many, investors I have in a particular state. The de minimis is only for state covered investment advisors. So I'm a state covered investment advisor in California, and I'm saying, I wonder if I have to register my firm in Nevada. And where the de minimis is if I have no more than 5 non-institutional customers in a 12-month period in Nevada, I would apply to de minimis. De minimis is Latin for it's so small, who cares, right? Now, if I'm an investment advisor rep, so an investment advisor representative, either federally covered or state covered, I know I'm registering in at least one state. So even if I'm federally covered, I'm going to register as a 65 or 66. You're taking a 63, so don't get too much in the weeds in this. I know you're excited. You might have to come back and take another exam. At some point, if you're going to be an agent of both the broker-dealer and an investment advisor rep, you're going to have to take another exam, either a 65 or a 66. But anyways, if you're an investment advisor representative, then of a federally covered investment advisor, you only have to register in a state in which you have a place of business. So if I have a place of business, I work for a federally covered investment advisor, and I'm don't have a place of business in Texas and I'm just flying in and out of Texas, I don't need to register. If I decide to open an office in Texas, well, then I'm going to have to, as a 65 or 66 investment advisor rep, place of business, I'm going to have to register. If we withdraw any registrations, that would take place on the noon of the 30th day after we have submitted our, our request to withdraw our registration. Renewals are always December 31st after the initial registration. So make sure you know the December 31st. And like I say, you're doing this, the day before your exam or the morning of. So I'm not sure how much time you have for remediation. As we said, these 60-minute series are just to kind of give you an intellectual inventory that hopefully while you're driving down the exam site, you're feeling like, oh, yeah, I know that, I'm not so sure how much you want to do after that. Now, if there's a successor firm, what we mean by that is I sell my firm to someone else. The new firm, the successor firm, doesn't have to pay new fees, right? So they don't have to pay new fees until the renewal. However, they have to, when they update their registration, right? Consent to service, very testable. So consent to service, remember, allows the state administrator to accept, legal documents on behalf of a securities professional. So, if I'm trying to serve you and I can't find you, I can serve the state administrator and you're considered served. There are certain things that would be problematic for our state administrator in terms of any convictions of securities fraud or for financial related misdemeanors, any felony in the past. When applying for registration, the administrator may ask about citizenship and proposed method of doing your business, how you're going to conduct business. If the application of the registration shows a conviction for a non-securities misdemeanor, but it is a felony in this state, the conviction is the one that counts. The misdemeanor of the one on the record is the one that counts. Again, low probability, but oh well. So when you terminate, the agents associated with the BD requires both the agent and the broker dealer to notify the administrator. The administrator retains jurisdiction for a period of 1 year after your termination. The BDs have net capital requirements, and investment advisors have net worth requirements. There is no net worth or net capital standard for an agent of a broker-dealer or an investment advisor representative. The administrator can't require a BD to have a net capital in excess of whatever they're required to have for their SEC minimums. Remember that 10,000, 35 grand is a state thing. Material change has to be reported promptly. Material is another key word. Material means something that might alter your decision. So I saw a broker being interviewed why he didn't tell the client this information. He said, I thought I'd lose the sale. That is the all-time worst answer. So any material change in the registration of a broker-dealer or an investment advisory firm requires a reported promptly. A BD exercising discretion or maintaining custody may have to post a surety bond. So all broker-dealers have surety bonds that cover the broker-dealer and the employees, unless the BD's net capital is in excess of the administrator's requirement. There is no, excuse me there. So let's just make sure we're clear about what we're saying here. Surety bonds are a must for a broker-dealer that covers the firm and the agents of the broker-dealer. Now, on the state level, if the state administrator has a net worth requirement of 10 or 35 grand, because that only applies to state, then that they can accept, the state administrator can accept a surety bond in lieu of the net worth of the broker-dealer. Record keeping, records have to be retained. And, it depends on the broker-dealer. Broker-dealers, the vast majority of broker-dealer records are 3 years. And investment advisor records are typically 5 years. So record keeping for BDs is 3, and that would include communications such as emails. And broker-dealers, again, are also members of what's called the Security Investor Protection Corporation. So registration of securities and issuers. So we've talked about registration of persons. And, what is a security? What is or is not a security? So we're talking about security. So let's first talk about what is not a security as defined in the Uniform Securities Act. Retirement plans are not securities, IRAs and KIOs, so forth. Non-variable insurance contracts, fixed annuities, term, whole life are not securities. Collectibles are not securities. Commodities are not securities. Precious metals are not securities. Condominiums that are used as personal residence are not securities. Currencies are not securities. Now, on the test, the state administrator cares more about issuer transactions. An issuer transaction is when the issuer receives the proceeds. Those are also called primary transactions. All those transactions together are called the primary market. Then the state administrator is less concerned with non-issuer transactions, where the previous owner receives the proceeds. Those are also known as secondary transactions. And all those together are called the secondary market. So under the Uniform Securities Act, the state administrator is way more concerned about issuer transactions or primary transactions than secondary transactions. So the registrations that we're talking about, registration of securities, from the issuer, is going to be dependent. We're not going to register securities that are trading in the secondary market. It's when we issue them or propose to issue them that we're going to register. Now, as I mentioned, the National Securities Market Improvement Act created federally covered investment advisors, but it also created federally covered securities, meaning these securities don't need to be registered under the Uniform Securities Act. And those are mutual funds, New York Stock Exchange and NASDAQ, and private placements under Reg D. Now, be careful. That doesn't mean that you can, rip people off or that they're not risky if they're federally covered. It just means, again, these securities, I don't need to worry about whether they're registered under the Uniform Securities Act. Now, methods of registering a security under the Uniform Securities Act, we can do notice filing. And technically, that's not registration. Technically, what that is for federally covered securities where I just make notification to the state administrator. Coordination. Coordination is what I use when I'm doing a traditional initial public offering under 33. I make my registration statement with the SEC. I'm registering the securities. I enter into a cooling off period, a quiet time of 10 to 20 days. And during that cooling off period or quiet time, I'm also coordinating with any of the states in which I plan on selling the security. So coordination is for an interstate offering of securities. And we're doing this concurrently when we're filing with the SEC. Not testable, that's called an S1 registration, traditional kind of taking a company public. We can also use qualification. And so that would be something that we can't qualify, or excuse me, we can't coordinate. So anything we can't make notice filing or coordinate is going to be done through qualification. That's the hardest one to do. So if I have a deal and I'm not registering with the SEC, for example, maybe I'm doing an intra-state offering securities. I'm only offering it in the state, a particular state. I'm not crossing any state lines, called Rule 147, who cares? But I can't coordinate because I'm not registering with the SEC. That doesn't mean I don't have to register with a state administrator. I'm certainly going to have to do that. And I do that through qualification. Now, once it's effective, the administrator calls me and says, Dean, you are effective to go now sell that to residents of the state of, I spent most of my career in California, so we'll say California. I have a year to try and sell money. Now, by the way, the 147 says I only sell to residents of the state of California. Again, this isn't about a Rule 147. The discussion I'm having with you is about qualification under the Uniform Securities Act. So my registration is effective for 1 year. Now, if I'm selling securities and it's the effective for 1 year, I can say, hey, I'd like to have some more time to sell some more securities. And the state administrator says, okay, fine, but don't change any of the terms. I can't change the terms. I can't say, oh, it's been harder than I thought, so I want to, lower the price, or it's been easier than I thought, so I want to raise the price, or it's harder to sell, I want a bigger commission because it's more work. No, I have to leave those terms in place. The state administrator might say, and Dean, why don't you check in with us every quarter just to make sure the deal is not going stale. So prospectus must be delivered prior to the effective date. And one other point about this coordination thing, if I am offering securities in more than one state, the state administrator doesn't care about the amount of securities I'm selling in other states. The state administrator only cares about the securities I'm selling in that state, right? So, what if I'm selling in more than one state, what are you selling in that state administrator's state? All right, so an exempt security is a noun, meaning it's a description of the type of security. An exempt transaction is a verb. What I mean by that is it's exempt because of the way we're selling it. So exempt security is a noun, meaning it's an exempt security by definition. And then exempt transaction is a verb because it's, how we actually are selling it that makes it exempt. So exempt securities include bonds or that are issued by foreign governments in which we have diplomatic relationships. I told you the Canadians are a little different, not Canadian corporations, but Canada, it's the only one where not only is the Canadian sovereign government exempt, but so are the political subdivisions, the provinces and the cities. For any other country, it's just the sovereign debt. So, it's only for the Republic of Mexico. It's not for Baja California or Ensenada. Whereas in Canada, it would be for the Canadian government, the provinces of Canada, British Columbia, and Vancouver. So a little different there. We're not be careful. RTFQ, that stands for read the full question, read the full answer set on your exam. So read the full question. This is not an exempt security is not about a foreign corporation. No, it's about a foreign government, right? So charitable organizations, scary but true, are exempt securities. Educational issues are exempt securities if they're nonprofits. So nonprofits are exempt. Now, exempt transactions, remember, is a verb, and it's how it's being sold and, the circumstances of how it's being sold. And isolated non-issuer transactions. So again, a key word, isolated. There's no pattern, right? So, you got certain important pivot words when you're doing a NASA exam. Unsolicited orders, where, that's the customer's idea. It's not my idea. Now, be careful on these exempt transactions. What I mean by that is it doesn't mean I, the agent of the broker dealer, doesn't need to be registered. It's that the security may or may not be registered because it's an exempt transaction, right? So be careful. Transactions with institutions, institutional investors are capable of protecting their own assets, their own interests. Again, it's about protecting Joe Sixpack, retail investors. Transactions between the issuer and the underwriter. A lot of times before a company goes public, the investment banking firm will clean up the balance sheet. The underwriter, Morgan Stanley, will say, well, listen, a lot of the stuff you have accounting as a private company is perfectly okay and legit as a private company, but it's not okay as a public company. So what we're going to need to do is clean things up by doing some reversing transactions between the issuer and Morgan Stanley. And again, state administrator doesn't care about the issuer and doesn't care about Morgan Stanley because both parties are capable of protecting their own assets, their own interests. Transactions by fiduciaries. Be careful about this one. What we mean by fiduciaries is officers of the court. We do not mean on your exam this afternoon or tomorrow. We do not mean a custodian of an UTM account. That's not what we mean. In the Uniform Securities Act template, what we mean is officer of the court. An executor or executrix of an estate, in liquidating the estate or doing transactions on behalf of the estate does not need to worry about running afoul of the Uniform Securities Act. A sheriff, maybe I'm a sheriff, asset forfeiture, I get some securities. I don't need to be worried as a sheriff about liquidating securities and running afoul of the Uniform Securities Act. I am a trustee in bankruptcy. The court has appointed me as a trustee in bankruptcy to, manage the estate, the corpus, that's a legal term for the body. And as a trustee in bankruptcy, I don't need to worry about running afoul of the Uniform Securities Act. And again, the state administrator, if anybody doesn't need to worry about running afoul of the Uniform Securities Act, it's the state administrator, right? So all those transactions done by fiduciaries are exempt transactions. Private placements. Private placement of the Uniform Securities Act. We're not talking about 33. We're talking about the Uniform Securities Act. A private placement is the 10 or fewer offers to non-institutional clients within 12 months. Pre-organization certificates with 10 or fewer subscribers. Even if the issuer or the transaction exempt, the agent must be properly registered. So make sure that you understand the exemption only applies to the security, not the agent of the broker-dealer. A properly registered agent may accept unsolicited orders from a retail client. Don't you love this? For a non-exempt, unregistered securities, because it is an exempt transaction. But remember, the properly registered agent is the key. So, if you're a properly registered agent, TD Ameritrade, for example, TD Ameritrade allows some, on an unsolicited basis, people to transact business in unregistered stocks, penny stocks, for example. The person at TD Ameritrade picking up the phone and handling that transaction is properly registered, right? So a properly registered agent may accept an unsolicited order from a retail client for a non-exempt, unregistered security because it's an exempt transaction. However, the administrator retains the right to have the clients acknowledge the order was truly unsolicited. I can't imagine any state administrator would not take TD Ameritrade's word for it, but I don't know if you saw Wolf of Wall Street. That's a real story about a real guy named Jordan Belfort in a real firm called Stratton Oakmont. And the state administrator, really, all these people, it was their idea. I don't believe it. I'd like, the client to acknowledge this is truly, unsolicited. A properly registered agent. So again, stressing to you, the point of taking the 63 is to become a properly registered agent of a broker-dealer. If you are a properly registered agent of a broker-dealer, you can offer a non-exempt, unregistered security to an institutional client, again, because it's an exempt transaction. Under the Uniform Securities Act, a non-exempt transaction may take place in the state only if the security is registered, exempt, or federally covered. So, sometimes we refer to all these things legally, not even the Uniform Securities Act, as safe harbors. If you ask an attorney about anything, what are the safe harbors? You were saying, how do I do this in a way that I stay out of trouble? And so here we're saying if you're a properly registered agent, you can offer it says the security is registered. So that means you coordinated it or you qualified it, or it was exempt. It was a U.S. government security or a municipal security, or it was a charitable, or it was a government we had foreign diplomatic relationships with, or it was federally covered. It was a mutual fund. It was New York. It was NASDAQ. It was Reg D. The burden of proof for qualifying for any of the exemptions falls upon the claimant. What that means in plain English is it's up to you to prove that you have availed yourself of whatever safe harbor or exemption you're using in terms of exempt security or an exempt transaction. As I said, any registration statement, you have to include the amount of securities you're going to be offered in the state and tell them whatever other state you're going to make an offer in, but you don't have to tell them the amount of securities sold elsewhere. The registration statement made by the issuer to the state administrator can be made by the issuer, the broker-dealer, or any interested party. And then, as I said, the state administrator may require you to update quarterly on the progress of the offering you've registered with the state administrator. All right, so let's talk about remedies and administrative provisions. So we've talked about registration of persons, we've talked about registrations of securities, and whether we need to register or not register the security. Let's talk about remedies and administrative provisions under the Uniform Securities Act. So one of the things that's not considered to be a transaction are subject to the jurisdiction of the state administrator is a gift of assessable stock. Now be very careful here. 3 letters can change the answer. A gift of assessable stock is considered to involve an offer or sale. So be real careful. If it's assessable stock, it's considered to be a transaction subject to the jurisdiction of the Uniform Securities Act. If it's non-assessable stock, it is not considered to be a transaction subject to the jurisdiction of the Uniform Securities Act. Say it again. I'm doing these in 30 minutes free form with my notes, about what I think I can get done in the 30 minutes we've allocated these videos. I want to be very clear. A gift of assessable stock is an offer or sale subject to the jurisdiction of the Uniform Securities Act. A gift of non-assessable stock is not. You want to be looking for a value, right? So anything of value, a security as a bonus, is considered to be a transaction subject to the Uniform Securities Act, right? So, you're looking at this idea of compensation or consideration. The Uniform Securities Act gives each state administrator jurisdiction on offers to buy or sell where the offers originate or directed or accepted. So I'm coming to you from Nevada. I suggest you use your own state is, the example when you're getting these questions. So I'm coming to you from Nevada, and I call you in California with an offer. So the offer originated in Nevada. It was directed to California. You in California say, hey, Dean, I'd like to think about it. I said, well, that makes sense. I'll check in with you tomorrow. And I check in with you tomorrow. And you say, yeah, I've thought about it. I accept the offer. And I say, hey, where you at? And you say, I'm in Oregon, checking out some wineries or breweries. And so the offer was accepted in Oregon. So in that example, the offer originated in Nevada. Nevada has jurisdiction. It was directed to California. California has jurisdiction. It was accepted in Oregon, and Oregon has jurisdiction. Now, it's not about where the check is drawn, where the bank is, or the transfer agent. So what I mean by that is if I say, okay, when can I expect the proceeds? You say, Dean, my family office is in North Dakota, and I'll have them send a cashier's check. North Dakota does not have jurisdiction. I say, great. When we get the check, I'll have the transfer agent in Colorado send you the certificates. Colorado does not have jurisdiction based on where the certificates were mailed from. Newspapers published within the state, but have 2/3 of their circulation out of the state, are not under the administrator's jurisdiction. All about power. What can the administrator do? Powers of the administrator. In this cast of characters, the play we're discussing, the most important person is the state administrator. The administrator powers include the ability to make rules and forms specific to the needs of the state. They don't pass laws. Laws are passed by the legislature. They can issue orders to specific persons, including cease and desist orders. They can seek injunctions from the court, but not make arrests. They can deny, suspend, or revoke a registration or cancel a registration or a license. They can subpoena witnesses or evidence and cancel and withdraw registrations as a non-punitive form of termination. The administrator would be within his or her rights to deny the registration of a broker-dealer if the broker-dealer has been subject to the disqualification by FINRA. An administrator may cancel the registration of agent due to inability to get in contact with the agent within a reasonable amount of time, death of the agent, or the agent has been declared mentally incompetent. The administrator can examine the books of a broker-dealer registered in another state anytime he wishes. Know the difference between a stop, a cease and desist, and a summary action. Summary action is an action taken without due process. Cease and desist tells you to, cease and desist. That's pretty straightforward. And the stop order actually comes from the court. And, the stop order says, stop. So stop orders generally apply to registration of a security, and like any order can be appealed to the appropriate court within 60 days. So a administrator has the power to vacate or modify a securities registration. And stop orders when the conditions that created the issuance of the security have changed and it's in the public interest. A cease and desist, the administrator can issue a cease and desist order to any person without prior hearing, and then failure to abide by that can lead to a court-imposed injunction. So stop orders generally apply to the registrations of a security, right? And then, if you don't stop, then the state administrator goes to court. So just know the stop is generally about the registration of a security, right? The cease and desist can be to a person, right? Not the security. Cease and desist is telling a person to cease and desist. And then summary is without the due process. Now, if the state administrator takes action against you without due process, then you can ask for a hearing within 15 days. So just by way of review, stops, orders are about registrations, cease and desist are about persons, and summary is action without due process. A civil suit under the terms of the Uniform Securities Act must be filed within 3 years of the alleged infraction or 2 years after discovery, whichever comes first. What do you get back? You get back or recover your principal and your interest and court costs and legal fees. It's not like you don't get more than that is the point. So, it's be careful. You don't tell me like you get some, triple damages or something. I shouldn't even bring it up in this video because now I'm telling you, you don't, right? You don't get more than what we just discussed. We definitely know the right of rescission. The right of rescission is you have 30 days to accept or reject the investment. You can say, well, Dean, I made some money, so I'm going to keep it. Or you can rescind. If you rescind, well, then, you can, get your money in the principal interest. Maximum criminal penalty under the Uniform Securities Act is a fine of $5,000, 3 years in prison, or both. Communications with customers and prospects. We need to disclose conflicts of interest. Sunlight's the best disinfectant. So, for example, if I'm recommending a company owned or controlled, or my, immediate family member is involved as a control person, that should be disclosed. Broker-dealer fees, not fees for investment advice, fees that broker-dealers charge to issue certificates or wire money, that kind of thing, needs to be disclosed. A BD is permitted to make reasonable charges for certain services. You can't misrepresent your registration or that of a security. So, two nasty words are approve and guarantee. If you use the word guarantee, you better be very clear. You're talking about a guarantee that comes from a third party, like a parent company on a debt of a subsidiary. Otherwise you shouldn't be using that word. And you shouldn't use the word approve, right? We never say something's approved by the regulators. We have what's called the customer identification procedure, SIP. And that means we need picture IDs to open accounts. Margin accounts require additional documentation. The credit and hypothecation agreement are mandatory. The loan consent form is not. I'm not going to go into a lecture on this. These are, Series 63 and 60 minutes. NASA requires that the customer receive a risk disclosure document telling the, trading on margin on leverage is hazardous to their financial health. Options, we need options disclosure document delivered to the customer prior to first trade and account approvable. And then they account approve, and then they have 15 days to get that back. Discretionary authority, be careful. We don't accept discretionary authority from third parties who don't have the proper documentation. So, my customer's assistant calls me and says, he told me to tell you. I said, well, don't take it personal, but we don't accept third parties telling us what somebody else said. If you have discretionary authority on the account, then more than happy to hear what, you want done. Now, what constitutes taking discretion? Remember, action, asset, amount. Action, whether buy or sell. Action, whether buy or sell. Asset, which security, and the amount. It doesn't apply to time and price, right? So that discretionary authority is granted. Time and price doesn't constitute that. Over and over and over again, state administrator says they make no distinction between electronic communications and written communications done the old-fashioned way. So any question about correspondence and social media, the pivot won't be about whether it's electronic or not. It'll be the content of the communication. Red flags. Red flags, the BD website is considering advertising and records on the site. We're going to have to post to the site a broker check and a link for broker check, and then, either a link or how to get the business continuity plan. And we said, 3-year records for that. The main thing about this this discussion is you have to have written supervisory procedures about social media. And, your reps have to read and sign, acknowledge what are your firm's things about how they can participate and whether they're going to use their own cybersecurity, they're going to use their own devices, or there's going to be a VPN, whatever the case may be. So All right. Well, ethical practices and obligations, again, a big part of the exam, don't lie, cheat, or steal. So no one and nothing is exempt from the anti-fraud provisions of the Uniform Securities Act, right? So don't get hung up on this idea of exempt. There's nothing, no thing, no one who's exempt from the anti-fraud provisions of the Uniform Securities Act. So an offering or sale of a non-exempt, unregistered security is going to be prohibited unless, remember, that verb that was done in an exempt transaction. We talked about disclosure of material facts, right? So it's okay if I don't disclose facts that are not material. I don't need to cloud your mind with stuff that's not material. But remember, material means it's something that might affect or alter your investment decision. So no omissions of our misstatements of material facts. We never mark or highlight a prospectus, because then again, people would say they only read the highlighted part, and the test assumes human depravity and original sin, that you'd only be highlighting the things that are good, right? So no marking. We don't trade on material non-public information, and again, the firm's written supervisory procedures have to have a section on that as well. So written supervisory procedures have sections on social media, cybersecurity, material information. Churning is very testable. Those are trades that are excessive in size and frequency. There's no real hard and fast definition of it. It's just the state administrators say we know it when we see it, right? So you're not supposed to engage in churning. You're not supposed to make unsuitable recommendations. Now, there's a lot less consensus on what's suitable given somebody's, investment, background. So we're going to test you on recognizing more often than not something clearly unsuitable given somebody's investment objective, because, that's a lot more consensus on what you clearly would not recommend for somebody. Usually blanket recommendations are going to be prohibited because every situation is unique. There are exceptions to that. For example, if my specialty is a particular type of investment vehicle, then I might be making a blanket recommendation. But in general, on the test, you should say blanket recommendations are prohibited because, again, every situation is unique. Be careful about prohibited practices that include borrowing monies or securities from a client, unless the client is a BD, so a financial institution, right? So the way we say that on the test is bona fide good faith. So if this is I'm borrowing money and I'm going through the normal process that anybody would do to borrow money from the bank or borrow money from the broker dealer in a margin account, that's fine. We're not talking about, again, we're talking about a non-natural person there. We're not talking about the loan officer of the bank and borrowing money from them. No, the institution, the financial institution. BD is opening accounts of premises of a financial institution. So, a lot of times banks have, agents or broker dealers in the location of the bank. So the BD that's operating off a banking premise, a banking location, is going to have to tell the customer both orally and in written form that they understand that they're not buying an FDIC insured investment like a CD. That disclosure is not required in a radio ad of 30 seconds or less. I've had people who disagree with me. I have a good friend I trust me. He said he's had people say they see that on the exam. I've never had anybody tell me they've seen that on exam. So you can, if you're watching this video on your way to exam, you see it today or tomorrow, drop me in the comment box of the video or whatever, reach out to me, and then I will call my friend and apologize for telling him that I didn't call him a liar. I just said I haven't had anybody tell me they've seen it. The BD's operations have to be physically separate from that of the bank. It is prohibited to enter fictitious information on the client account. Some of the stuff should be layups for you, right? We don't want to, it's called data gathering, and we got to make sure we're doing that correctly. It's not testable in the 63, but within 30 days, I send you a copy. Any changes, I send you a copy. In every 6 months, I send you, or every 36 months, I send you a copy. Front running, trading ahead of customers, that's a big, big no-no. That's where we enter orders for the benefit of ourselves ahead of the customer orders, big no-no. The signed margin agreements must be received after the initial trade, not prior to it. So, just be careful, RTFQ, RTFA. I don't think that's a big deal, but Any written customer complaint must be promptly brought to the attention of the appropriate supervisor. Complaint sent by email is considered written, right? So we said there's no distinction on the exam between, this how the communication is made, whether it's snail mail or email. It is prohibited to attempt to obtain written agreement from a customer. They'll not use the agent to the sale of certain securities in violation of state law. So what we're saying here is you can't get a hedge clause. You can't get a customer to agree that even though you may be ripping them off, that they're not going to hold you accountable. So that's what that's kind of saying there, right? So that will be deemed not to be, binding on you, right? It's like, I think of it like I take out a hit on somebody, a mobster, you don't fulfill the contract, and then I take you to court. It's a non-binding contract. Agents, be careful. I don't know if any firm's going to let you this. Only agents of the broker-dealer, not broker-dealers, not investment advisors, not investment advisor reps, but agents of a broker-dealer can share in a customer account with proportionate capital and principal approval. I don't know of any broker-dealer that's going to give you written permission or get written permission from the client and the BD and allow you to do this. But the test answer is an agent of a broker-dealer can share in a customer account with proportionate capital and principal approval. Only true of an agent of a broker-dealer, what you're taking, 63, not true of the firms, broker-dealers, or investment advisors, or an investment advisor representative. Again, disclosures of loads, a fund that has a contingent deferred sales charge is still a loaded fund and needs to be described as such. A promotional expense can only be 1/4 of 1% if you still want to refer to the fund or hold the fund out or advertise as a no-load fund. If you go excess of 1/4, 1%, 25 basis points, you can no longer refer to yourself as a no-load fund. A breakpoint is a quantity discount. Be careful, RTFQ again. Breakpoints are good, but breakpoint sales are bad. So breakpoints are good. Quantity discounts, breakpoint sales are bad. Now, breakpoint sale, remember, is where you avoid the breakpoint to maximize your commission. Very, very much a prohibited practice. I mentioned being careful about the third-party guarantee. It's okay if it's a parent company and you're making sure you're using that word properly, or if it's a treasury security, but in general, don't use the word approve and guarantee. Arbitrage is a legal practice. Arbitrage is not prohibited. Arbitrage is simply profiting from price discrepancies, right? That's what arbitrage is. So, a price discrepancy, and it's not prohibited. I see the security trading on one market center at X and trading on another market center at B, and those prices are different. And so I short it in the market that has the higher price and buy it back in the market that has the lower price. So just the point is, arbitrage is not a prohibited practice. Selling away most certainly is. You have an approved product list at the firm. You're not supposed to get people involved in investments that aren't sponsored by your broker-dealer. And, if you sell an investment not sponsored by your broker-dealer without permission, that's a prohibited practice and is known as, test question, selling away. Selling away is a prohibited practice. That's selling investments not sponsored by your broker-dealer without written consent from the broker-dealer. Not likely to give it to you, but if they did, they'd send every customer something saying, hey, don't come whining to us if you lose your money. Kind of, again, straightforward, but if you offer a complimentary service, it's got to be complimentary, right? At no cost or obligation. What they have in mind here on the test is like a portfolio review. You can't then, when they come in, say, well, no, you got to open the account. No. We don't disclose confidential client information, very testable. Now, the testable exception is if we're responding to the court or the IRS or a spouse on a joint account. But other than that, as an investment advisor, client information has to should remain confidential. No surprise, right? So this is pretty straightforward. In other words, if I'm going to share that I manage money for, I need your permission. If we're going to be acting as a principal in a transaction, as an investment advisory firm, that too would be disclosed. That's called capacity. So, we always disclose capacity as a broker-dealer, but it's even more important than investment advisors, because investment advisors are fiduciaries. I'm just going through my notes here. I'm coming up on my 60 minutes. So, a stock certificate. So as much as we try and explain the relationship of the investment advisory firm. So my firm was called Gamma Global Investment Advisors. I used to say, listen, I can't steal what I don't touch. I use Schwab Institutional Group for custody, execution. And so we're going to open an account there. You're going to be a customer of Schwab, the broker dealer, and Gamma Global Investment Advisors. And so you say, hey, Dean, I just came into $500,000. We're going to put it in the account and you have some more money to manage. I go, wonderful. And you don't understand that that check should be sent to Schwab or made payable to Schwab. And so I open the mail and there's a $500,000 check made payable to Gamma Global Investment Advisors. So now I have 3 days, 3 business days upon receiving it. The test phraseology here, again, another P word is inadvertently. So monies or securities were inadvertently mailed to the investment advisor. The investment advisor should return the money or securities promptly. That means within 3 business days upon receiving it, right? Unless I'm allowed to maintain custody. In this scenario, I'm certainly not, right? So that 3 business day is key, and inadvertently is key. We already talked about cybersecurity and data protection, and we said that in the written supervisory procedures of the broker dealer. Oh, by the way, one more thing. Whether I'm using Schwab for custody and execution, or if I'm a broker dealer, or excuse me, an investment advisor where I have custody, it doesn't matter. The customer is entitled to a statement quarterly. Again, it's just much easier to use broker dealers because they're already prepared to do that. Cybersecurity, data protection. We said we have to have written supervisory procedures to identify identity theft. So red flags about identity theft. They use sometimes the term red flag for like money laundering or identity theft, and they give you a scenario. And where's the red flag? Like if it's money laundering, the source of funds, or it's commercially illogical, whatever the case may be. If we are going to, we report all breaches of cybersecurity, and then we're required to plug the gap. And they sometimes ask you, who's the first line of defense in both cybersecurity and money laundering? And it would be you, the agent. You, the agent, are the first line of defense in whether it's cybersecurity or money laundering. Okay, so I hope you're finding these series exams in 60 minutes to be helpful. This is the 63. What's up next is 9, 10, and 24. We already have these for the 6, the 7, the SIE, and now the 63. We have it for the 65, the 66. And so I'll put this in the appropriate playlist in 63. I'm coming to you in September of 2022. The internet lives forever, but I hope to have another 63 practice exam up shortly. I have 2 there, or 1 there now, and I'm hoping to have a second one up shortly. So check back on the playlist, depending on when you're testing, that may be helpful or not. Okay, remember, inch by inch, the 63 is a cinch. Oh, well, I'm sorry. You won't be circling back because I forgot. We're making this video to be watched the day before or this afternoon. So, hey, bon chance, mon ami. That's French for good luck, my friend. I hope you pass. Circle back and tell us what happened to you. And we're sending you good testing vibes. Bye-bye.